Assistant District Attorney Robert Cosgrove. The matter is on for discovery motions. If the parties could please state their appearances for the record.
Good afternoon, Your Honor. Robert Cosgrove, Special Assistant Attorney for the Commonwealth.
Hey, D.A. Cosgrove, good afternoon.
Hello, Your Honor. Timothy Bradle on behalf of Aidan Kearney. Before the court is my client, Aidan Kearney.
Attorney Bradle, Mr. Kearney, good afternoon.
Good afternoon.
And Your Honor, one of the motions that I believe is on for today is the Rule 17 motion.
Correct.
I don't know if anybody from Verizon is here. I did give them notice as ordered by the court, but I am aware that the owner of the cell phone has retained an attorney, and she is here to address the court. I don't know if she wants to introduce herself at this time.
Morning, Your Honor. Sorry, Tanya Gravel on behalf of Ms. Katani.
Good afternoon, Ms. Graham.
And Your Honor, before we begin getting into the motions before the court today, could Mr. Bradle and I be heard briefly at sidebar?
Of course. Thank you.
So if I may, Your Honor,
Please.
it seems to me, I don't know what new issues we might take up today, but it seems to me the last time there were 4 or 5 things that we discussed that the court was looking for responses on. One was the Rule 14 discovery motion. The second, the court directed me to file a response to the motion for special discovery. Third was the Rule 17 motion that I've already alluded to. Fourth was the motion to disqualify special counsel, which was put over to today. I don't know if we're going forward on that today or not. And finally, the court inquired about the status of a motion for a bill of particulars. I informed the court at that time that I understood that Mr. Mello was working on it. And my understanding is he has since filed a bill of particulars. I might imagine that Mr. Bradel has some comments to make about that, but I guess we'll find out. So that pretty much covers, I think, what's
And in terms of,
from last time.
I know that you had filed, I'm sorry to interrupt you, but I know that you had filed notices of the discovery that has been provided up to this point. There were copies of letters that were provided to Attorney Bradel. What's your sense, ADA Cosgrove, of where discovery stands at this point on both cases?
Well, I think we're probably at the point, I would say, where 98% of the discovery has been provided. There are a few things that I want to do further investigation of. I expect that most of those can be cleared up fairly quickly. I will say that when I walked into court for the first time on this case for hearing before Your Honor, I thought that discovery was almost completed then, and Mr. Bradel surprised me with a fairly lengthy list of things that he was missing that I have since done my best to respond to. To what extent to his satisfaction, I don't know. So we'll see what today brings. But I think most of the Rule 14 discovery should probably be provided fairly presently. And then I'll file a comprehensive list and a certification that I have done so. I don't want to certify that I've provided all the discovery until I'm confident that I have.
Understandable. And I know that you did file a response to the request for special request for discovery, that there were certain areas that you had outlined where there were objections to that, to certain requests, and also indicated whether they had been, they were in the custody and control of the Commonwealth at this point as well, too. So I'll hear.
Yes, and I hope I understood correctly that what Your Honor asked me to do was to respond to the motion, not that you had allowed the motion, and that I was to provide it, although Your Honor is obviously prepared by reading the materials. You can see that from the letter that I provided Mr. Bradel, that some of the discovery he asked for that the Commonwealth agreed to, I included right in the letter.
Okay, thank you. Attorney Bradel, what's your position on where discovery stands now?
Judge, I have a different view of it. There's a lot of really important things that are not provided. The first area that I want to talk about, Judge, is my client's phones and computers that were taken out of his home a very long time ago. And we have nothing in terms of the contents that was taken from my client. And that's a huge problem. And there's a lot of reasons why my client needs those items back. You know, he's a professional journalist. They took all of his work product from his entire career. And in there are confidential sources. There's personal communications. There's medical things. There's investigative things on the very same state police officers that are charging him here. So they have a self-interest and a conflict in getting into his devices. And they've kept these things for months and months and months.
Those were seized pursuant to a search warrant?
Yes, Your Honor. And we've never seen hide or hair of any of it. And now that brings me to my second point, which is that the government is bound by the strictures of preventive medicine here. It's the case that requires when the government seizes, items that implicate an attorney-client privilege, and we would contend other privileges as well, such as the attorney, as the journalist privilege, husband-wife disqualification. There's all sorts of privileges that would be implicated by the fact that they took all of his electronic devices. And but at a bare minimum, preventive medicine talks about attorney-client privilege items. And Mr. Kearney has been involved in litigation as of the time of the seizure, unrelated to this. Civil things, restraining orders, other cases where he's the victim, all kinds of attorney-client communications are filled in his electronic devices. And we haven't been given a copy of that. And at the same time, the government is supposed to comply with preventive medicine, which they haven't, and I'll get to that in a second. But nothing in their duty to comply with preventive medicine stops them from giving us back, either give us back the items, because we know they took a mirror image of everything, give him back his physical items, number one. And if they don't want to do that, if they want to trip him up somehow and not give him the items back, they needed to give us the discovery by May 8th, Your Honor's first deadline, by June 13th, Your Honor's second deadline. How about by today? We still don't have anything in terms of my client's phones. And they could have given us...
Let me just stop you there for a minute. 88 Cosgrove, is that within the 2% of the discovery that's still outstanding?
No, actually, Your Honor, Mr. Bradle brings up a point that I was intending to address with you a little later this afternoon, but since we've come to it now, let me address it now. There are actually 5 search warrants involved in this case. Two of them involving a different party, and 3 of them involving the defendant. One was for his home, one was for things like cell phone, portable devices, and one was for his vehicle. And I just have a little, read you a little excerpt, one paragraph from a 32-page affidavit that will give you flavor, I think, of what was alleged in the warrant. I have it.
While you're looking for that, is there a reason why the items that were seized have not been copied and provided as part of discovery?
Yes, and I will explain that. Apparently don't have it, my apologies. Shortly after the items were seized, and this predates my involvement on the case, so I don't know if Attorney Bradle wishes to comment on this point. My understanding was that Attorney Bradle was in touch with Attorney Mello and said, can't go ahead and search these because we need a taint team procedure under preventative medicine. Attorney Mello agreed to that and set about finding some personnel for the taint team, which he identified. I was actually originally brought onto this case, Your Honor, to provide advice on legal issues, among them putting together a motion to set up a taint team. before I could get oriented and underway on that, Attorney Mello experienced some personal illness, so I have been pressed into other matters of which Your Honor is quite familiar, and that has taken me away from putting together a motion for a taint team, although I have completed a draft out for several people to look at, and I hope to file it shortly. But as Your Honor knows, the normal process with the taint team is that a forensic investigator, an assistant district attorney or assistant attorney general in the office who are not involved in working on the case or the investigation in any way is assigned to do a preliminary screen to filter out possible attorney-client privilege materials, and then the specially assigned assistant DA, who is on the taint team, looks at those materials, makes an initial determination of whether they contain attorney-client privilege material, and then provides that list to the court along with a copy of the seized items to the defendant, or at least to the person whose electronic devices are being examined. In this case, it's the same person. That person and his attorney then have an opportunity to examine the list with the aid of copies of their own devices and come back and make an argument to the court as to other things that should be excluded that they claim the so-called taint team has missed. The court makes a ruling on that. Then once that's taken care of, the results are turned over to the prosecuting team and search commences of the materials that are not deemed to contain the attorney-client privilege. I think we are almost ready to proceed on that. In this case, because of the district attorney's desire to separate this from another ongoing case and to have a special prosecutor assigned to the case, we don't have the option of using another ADA in the office or another forensic examiner who works for the DA's office for the taint team. That would more or less defeat the purpose of the special prosecutor. So we have identified outside people to do this. I did happen to speak just yesterday to the person identified that we intend to identify as the forensic examiner to make sure that he was still on board, since it's been a while, as Mr. Bradle correctly points out, and I'm advised that he is. So I would expect that hopefully by the next time I'm